rasa tidak puas hati, and in this particular case, it's quite a shocking decision that they have told that the non-Muslim has to go back to Syariah Court, and the non-Muslims in this country will never submit to the Syariah Court, and we stand there. And Nazri, the minister, the Prime Minister's department, made a statement. He has been making statement every year by year, saying that there will be some remedy for the non-Muslims. However, the remedy never came, and we are still waiting for the remedy. And we will be doing the necessary appeal on this matter.
We will take it up to the court, to the federal court. We will be taking it up to the federal court. We will file for leave to appeal to the federal court.
When will you be filing for leave?
Yeah, immediately. So we have 1 month. We will do it immediately.
Within this week itself?
Within this week. Well, next week. Today is Friday, so within next week.
The whole problem is 121A, which we have spoken very widely in Parliament, that the amendment that took place in 1988 is both unfair and unreasonable to the non-Muslims in this country. The decision today very clearly shows that there is a new thinking by the judges in this country that we have to submit to the jurisdiction of the Syariah Court. Non-Muslims do not have a right to appear in Syariah Court. So how can we be appearing before the Syariah Court? And this ambiguity, this unclearness must be cleared by an amendment in Parliament. And we will be pushing for it. We have been asking Parliament in no uncertain terms that some changes must come about, where the non-Malay rights not only must be protected, but must be made it very clear that the civil courts are the only avenue, and the judges must address these matters in the civil court.
Danger that we have, there will be a clear-cut biasness on the non-Muslims. We are not saying the existence of the Sharia court is biased, but when they stray into areas which they have no jurisdiction to determine the religious status of other non-Muslims, that is why we say there is biasness on the part of the non-Muslims. So this involves Article 121(1)(a) of the Federal Constitution. So therefore, we feel that there will be clear-cut biasness, there will be no right of hearing, there will be no opportunity to be heard, the right of access to the right court will be denied. So we will take it up to the federal court, let the highest court in the country decide on this matter, on the Article 121(1)(a) of the Federal Constitution.
But earlier the court argued that the Sharia court has the that they have the expertise. The Sharia court has the expertise to decide on such matters as it is within Islam.
But there will be biasness on the part of the Sharia court, because this involves when there is a dispute on the religious status of a particular person. One person is saying that I am not a Muslim. One person is contesting on the religious status of a particular individual. So when a non-Muslim contests the religious status of a particular individual, the best forum will be the civil court. The civil court has the jurisdiction to hear. So we don't want religious court to stray into areas which they have no jurisdiction to hear. So we don't want Sharia court to come into the areas when they have no jurisdiction in the first place to determine religious status of a non-Muslim. We have stated in our affidavit, clearly the wife is here, saying my husband is all along a non-Muslim. He is a practicing non-Muslim. So therefore, I feel there will be a clear-cut biasness on the Sharia court to stray into the areas of other religion. We cannot stray into areas of other religion. So, if it is strictly on the Islam, then fine. But they shouldn't stray into other areas. They shouldn't go into areas which is not their jurisdiction. So it's unfair. It will be clear-cut bias on non-Muslims to go and seek declarations from Sharia court to know about their religious status. Clear-cut bias. So there will be also no right of hearing. In her case, when Moorthy's religious status was determined, there was no notice sent to her. She was not given an opportunity to be heard in the right place. In any event, she does not want to go to a Sharia court to determine her husband's status. She wants the civil court to decide on her husband's status, a religious status. She wants the civil court to determine what is the religion of her husband. when all along to her eyes, he was practicing Hindu. So that is the thing, you see. So we don't want Sharia courts. It is a very sad decision. We will take it up. Of course, it's heartbreaking. We have to take it up. There's a proper way of taking it up. We will take it up to the federal court, and let the federal court decide once and for all. Okay, it's not fair to ask a non-Muslim to appear before a Sharia court when the Sharia court is best jurisdiction only to deal with matters pertaining to Islam. So if when someone disputes on matters other than Islam, then the best forum will be the civil courts.
Will you say that today's judgment has been very grave?
Yeah, I'm extremely disappointed. I am it's shocking, it's appalling. At the same time, we have to, yes, once the decision is made, we have to take it up to the highest level. And we will go. We already waited for the last 5 years. So we will wait.